My colleagues and I will come around with index cards in case you have any questions for them. We're going to let conversation just go for a bit, okay? Thank you so much.
Well, for those of you who are fans of unplanned events, this would be the classic example. We haven't actually prepared anything, but both of us, it turns out, have questions. Each of us has questions for the other. So, the professor has kindly agreed to let me start. I was wondering if you could compare the public reaction in Germany to the Frankfurt trial with the reaction to the Nuremberg trial.
So, yeah, I mean, what's interesting in the German context is that, at least initially, the Nuremberg trial, and particularly the international trial, is probably pretty popular. The reasons for this may not be as reassuring as we would like, though. There's a very widespread sense in Germany in the late 40s that they are among the chief victims of the Second World War. Right? Some of this has to do with things that the Allies did, obviously the bombing of German cities, the atrocities committed by the Soviets as they advanced into Eastern Germany, the mass rape of German women. But, of course, they can't easily say, oh, well, we're innocent victims of you occupying powers, so they tend to frame themselves as victims of the Nazis, right? And so the Nuremberg trial, in particular, because it's a small number of very elite individuals, actually plays into the hands of a lot of Germans in that regard. They say, oh yeah, that Goering guy, it was all his fault. And Franz and I, we didn't do anything. So we're the victims here. With the successor trials that I didn't talk about a lot, but those went after, I mean, still basically elite members of German society, but not just government elites. There was a doctor's trial, there was a judge's trial, there was a trial of Die Einsatzgruppen, which was the only really major Allied trial that dealt directly with the Holocaust. The trials became increasingly less popular as they pointed more and more in the direction of broad segments of German society being complicitous with Nazi crimes. And so by the early 50s, the percentage, I don't remember the exact number off the top of my head, but the percentage of Germans in polling data who agree with the statement the Nuremberg trials were fair falls to about 30%. Right? And whereas it's in the 60% plus range in 47, 48, right? So the Germans really strongly turn against the Nuremberg trial as they move into the 50s. And then in that respect, it's actually fairly similar. The numbers are relatively close to those of the Auschwitz trial, which shows that this period from, say, 49, I think the real sea change comes in the 70s in Germany. So from the late 40s through the 70s, I would say the substantial majority of Germans basically think that Nazi trials should be brought to a close, that whatever wrongdoing there was restricted to a small number of people. Those people have been prosecuted now, and it's time to go on and move ahead and get on with life.
Very interesting, because what I have seen written in the past is that Germans reacted very badly to Nuremberg, seeing it as victor's justice, and that it was the Auschwitz trial that changed a lot of minds, because there it was Germans pursuing justice. But that's an exaggeration.
I think that's an exaggeration. I mean, you would think, I mean, clearly the Auschwitz trial didn't suffer from the perception of victor's justice in the same way. It did, certainly in nationalist circles, suffer from the perception of being Jewish justice. The fact that Bauer was himself Jewish, the fact that most of the witnesses were Jewish. Now, not the majority of Germans there. It's hard, the polling data didn't say, are you a raging anti-Semite? So it's hard to get a sense for what percentage of those people who rejected the trial did so out of anti-Semitism versus did so out of some kind of sense of wounded national pride or the like. But I really think that the trial helps put the name of Auschwitz out there in really important ways, and it gets picked up by the student movement that's sort of gestating in precisely that time period. but the student movement itself does weird things with it, right? I mean, if you look at, student protest movements in Germany in the 60s, and they're all carrying signs saying LBJ equals Hitler, right? And so, yes, they talk a lot about Auschwitz, but they talk about Auschwitz in the context of Vietnam, right? And that's, whatever one thinks about the Vietnam War, it ain't Auschwitz, right? And so, in that sense, that's still weird. I actually, personally, think, and I think there's data to suggest this, that the big breakthrough in Germany comes with the screening of the American miniseries Holocaust, which screens in Germany in 78, I believe, maybe 79. And there is, quite literally kind of a mass hysteria in Germany that comes out in response to that miniseries, and it's almost like the Orson Welles thing. I mean, there are tens of thousands of letters written to the newspaper, written to the TV station saying, "We didn't know. This is so terrible." And I think that actually really then is the breakthrough. It also, of course, coincides with generational shifts, right?
Yeah. It's interesting you should mention that miniseries, and I'd forgotten about it, but I also recall that reading that it was having an enormous impact in Germany at the time, and I recall that around the time of the screening, the statute of limitations on the prosecution of Nazi murders in Germany was about to run, and I was actually, as a law student, working with some others on a campaign to persuade the German parliament to extend the statute indefinitely, and we actually got to meet with the then Chancellor of Germany, Helmut Schmidt, when he visited Harvard to be the commencement speaker, and was very candid about the challenges in Germany to getting the parliament to extend it. But a lot of us were, when the parliament finally did the right thing, those of us who wanted to take some of the credit for that were quickly disabused of that notion when it was explained to us that actually it was this NBC miniseries that more than anything else changed German opinion by personalizing the horrors of the Holocaust, much in the way that Anne Frank Steiger did.
Yeah, no, I think, one of the things that is really crucial in this is that putting a human face on the victims. I mean, the trials can do that as well. All right, and then, the Eichmann trial famously relied heavily on, and you mentioned this in your talk, on witness testimony. The Auschwitz trial as well, there were 350 witnesses, about 220 of those were Jewish survivors, the rest were other kinds of survivors, or a fair number of SS men testified as well, curiously enough, mostly called by the prosecution. And they spent most of their testimony saying it was the other guy, not me. As you might
Sounds
imagine.
familiar.
Yeah, they were really awkward, right? Because they were called by the prosecution, but they spent most of the time trying to not implicate themselves, right, in what they had seen. But I think in the trial setting, certainly in the Auschwitz trial, and Nuremberg, of course, famously didn't use much eyewitness testimony, right? But in the Auschwitz trial, where they did, it was very difficult for the survivors who testified because the court had to ask for a level of precision in their testimony that's frankly not realistic. And the defense, there were some really egregious right-wingers on the defense team, but even the defense attorneys who were decent men just doing their job would tend to ask in cross-examination questions that, if you're a survivor, would be, very offensive, frankly, right? Are you really sure? Did you have your glasses with you when you saw this guy beating your wife to death? And so, it was very, very difficult for the survivor witnesses. And the court, in contrast to the Eichmann trial, where the court was more solicitous of this, was not interested in letting these people just tell their story. Right? So there's a constant kind of give and take where the witness is saying, oh, and let me tell you about my children. And the court said, well, that's very well, Mr. Goldschmidt, but we're not interested in your children. We just want to know whether you saw the defendant, Muluka, at the ramp on the day of your deportation. Right? And so that kind of personalization wasn't able to come through as much because this wasn't people just telling their story, right? This was people answering very forensically specific kinds of questions.
Mm-hmm. Right. In this country, The Nuremberg trials are well known. The Eichmann trial also reasonably well known. The Auschwitz trial, much less so. It was big news, I remember as a kid, vaguely. Big news in the 60s as it was occurring, at least big news in the New York newspaper media. And then largely faded from public consciousness, and I'm so grateful for your book, which begins to bring the trial back into public consciousness. And those of you who teach at the college level, I commend Professor Fanya's book to you very enthusiastically. I don't think it's necessarily the best work for high school students, but for teachers it is. And I don't know how the professor feels about it, but we'll find out in a moment. I think that the German 3-hour television documentary on the Auschwitz trial, which mixes some actual film footage of the courtroom proceedings, and outside the courtroom, audio recordings of some of the witness testimony, and brings in segments of Holocaust education, is exceedingly well done. And it was produced with English subtitles a few years ago by Brandeis University. You see it on eBay all the time. I'm trying to remember.
It's on Amazon too. It's called Verdict on Auschwitz.
Verdict on Auschwitz. And if you can devote 3 hours of classroom time to it, presumably over 3 days, I think it's a tour de force.
It's a two DVD thing. It has the 3-hour version, which is the German original, which is subtitled, which is really, really, really good. And then there's a 1-hour dubbed version, dubbed into English, which is not so good because it loses a lot of the context and stuff, but it is only 1 hour, so it's probably more suitable for classroom use, and it's dubbed into English, so you don't have the problem with eyes glazing over with subtitles. Like I said, the 1-hour version is not as good, but it's still, I really recommend it very highly.
I don't want to give away how this ends, but I will say this. When I watch this program at home by myself, there's a closing scene involving the notorious Auschwitz torturer Professor Penn just mentioned, Wilhelm Boger, and for a moment I was terrified, and I had to remind myself, wait a minute, you know, it's the 21st century, Boger is dead, and I'm on the other side of the ocean. Take it easy. It's that powerful. Okay.
Yeah.
Oh,
okay,
yeah.
so here's the first question for me. Your description of German criminal code definition of murder accessory seems odd indeed. Was this post-war intervention to protect Nazis? It's worse. The definition of murder that I read out, that includes the base motives, sexual desire, bloodlust, etc., that's a change in the German criminal code from 1940. Right, so this is an actual Nazi statute that is put in place. The backstory to this is very complicated. It comes in part actually out of progressive early 20th century criminological attempts to get away from what I call the Les Miserables problem. If you define murder only as a specific act, right, without reference to the motives behind the act, you can end up in a situation like Jean Valjean, right? Steals a loaf of bread to feed his kid, is pursued by the police for all eternity because it doesn't matter why he stole the bread, he stole the bread, he's guilty. So progressive criminologists and jurists in the beginning of the 20th century said we need to figure out, take into account why somebody commits a crime as well as what their action is. So that's a kind of a progressive move at the beginning of the 20th century. The Nazis pick up on this, though, and are, in classic Nazi ideological fashion, very interested in this question of will, right? The will of the people is what matters, and above all, they think that sometimes killing is good and necessary, like killing Jews. Right? Sometimes killing is wrong and criminal, like killing Nazis, right? And so they want to appropriate this originally kind of progressive criminological development and incorporate it into law. And then after the war, I didn't have time to talk about denazification, but one of the things that falls under the rubric of denazification after the war is the denazification of the legal code. And so Karl Lowenstein, who's an exiled jurist from Germany who teaches at Columbia after the war, gets this job of going through the German legal code and saying, this is a Nazi law, that's not a Nazi law, this can stay, that has to go. Somehow he misses this 1940 change to the definition of the murder. So it's literally a Nazi statute that is being used to prosecute these Nazi criminals after the war. And interestingly, quickly also, the Germans, unlike the occupation period, can't prosecute crimes against humanity. Right? So during the occupation period, German courts would prosecute Nazi crimes as crimes against humanity as defined at Nuremberg, but when Germany gets sovereignty back in 1949 with the founding of the Federal Republic, they say that violates the ex post facto prohibition. We're not going to apply crimes against humanity going forward any longer. So that means they have to have this weird definition of murder. And manslaughter falls under the statute of limitations in 1960, right? And so they're left with this indeed very weird, especially from an American point of view, very weird understanding of murder. I was the Auschwitz trial book was just published in German, and I was there in November doing a little book tour and talking to German audiences, and a lot of people would come up to me afterwards and say, it's so weird that you think that definition is weird. They're like, now I finally understand those dubbed episodes of Law and Order that I've been watching all those years. Because for them now, of course, this is just internalized. This is the way the law works, right? From an outside vantage point, in the American context where it's about intent, it does seem really weird.
So I have two related questions. Why didn't Israel pursue other Nazi criminals, that is, other than Eichmann, and bring them to Israel to face justice? Was Eichmann the only one tried? And there's a related question regarding Demjanjuk, which is why didn't I start my discussion of Demjanjuk, which was necessarily very brief, with something like after the failure of the Israeli justice system. So let me address this. I don't represent the Israeli government, so they would have to answer this question. But let me say first, Eichmann was not the only person tried. After Israel passed its statute in 1950, criminalizing, albeit retroactively, which made the Eichmann trial, by the way, additionally controversial internationally, criminalizing Nazi crimes. Prosecutions were commenced in Israel, during the 50s in particular, against Jewish collaborators who had settled in Israel after the war. And there were quite a few of those and quite a number of convictions, though Eichmann remains the only person in Israeli history ever executed following conviction. In addition to Eichmann, the Israelis did try in 1960, when they were pursuing Eichmann, to apprehend the infamous Auschwitz selector and experimenter Dr. Yosef Mengele, but they were, for various reasons, unable to get their hands on him, so he was not tried and ultimately escaped justice. And by the way, the story of how he escaped justice is told in a report that my office released, and I think it's brilliant, and I say that principally because its main author was David Marwell, and it too is on our website, and I commend it to your attention. The Israelis did prosecute one other Nazi, and that was John Demjanjuk, and many of you will remember that story. It's long, convoluted. If I had a few hours, I could relate it in some detail. We don't, so I won't. But before we at the Justice Department prosecuted him to revoke citizenship and then obtain removal on the basis of his involvement in murder at the Nazi death camp in Sobibor, Poland, there was a prior Justice Department series of proceedings in which Demjanjuk was accused of having murdered people at the Treblinka death camp, where ostensibly he was known to the prisoners as Ivan the Terrible for his particularly ghastly conduct. On the basis of that evidence, he was deprived of citizenship here, or his citizenship was revoked. He was ordered removed, and he was in fact extradited to Israel, where they tried him on the Treblinka charges. He was convicted But there was no failure of the Israeli justice system. To Demjanjuk's great fortune, as his death sentence was on appeal, something happened that I dare say none of us could have anticipated. It was a great event, namely the collapse of the Soviet Union. And for the first time, even just before the Soviet Union collapsed, its archives, or some of its archives, became available, accessible to Western investigators. Israeli prosecutors got in there. They found evidence that cast substantial doubt on the case that Demjanjuk had served at Treblinka. They did what they are obligated by Israeli law to do, as we would be obligated under our law, namely they handed that evidence over to the defense. The defense used it, of course, on appeal. The Supreme Court reversed Demjanjuk's conviction, released him, and he came to jail. So I tend to view that as a triumph of the system. That's the way it's supposed to work. The goal for prosecutors like my colleagues and myself is not to win convictions, it's to do justice. That's the highest goal.
So I've got a couple here that feed right directly into each other. First, were there non-biased German judges? It seems to me they were nationalistic with not too many convictions, right? So, and then I think directly related to this is, could you speak about the impact of denazification on German society? In this context, one of the most important impacts of denazification on German society was that there ultimately wasn't much of it. And that means that the vast majority of judges well into the 1960s were people who had been active during the Third Reich. Right? In the occupation period, right, there were obviously substantial efforts at denazification. The idea was to remove from public life people who had been active Nazis. But even during the occupation period, this had trouble reaching large numbers of people, right? So only 30% of the judges in the British occupation zone from 45 to 49 were removed from office as a result of denazification proceedings. So that means 70% of judges stayed in office throughout the occupation period in the British zone. Of the 30% who were removed, once the Federal Republic regains sovereignty, it begins a deliberate process of reintegrating people, Nazis, back into German public life. So 80-some% of people who had been removed from public life by denazification are brought back in. They get their jobs back. If they're of retirement age, they at least get their pensions restored. Right? So by the early 50s, essentially every major public official who had been active in the Third Reich, below the level of, say, cabinet ministers and the like, right, are back in public life. And even in some cases, even at the level of cabinet minister, Konrad Adenauer, the long-serving first chancellor of West Germany, his chief of staff is a guy named Hans Lobke, who is the author of the authoritative legal commentary on the Nuremberg race laws. Right, which had begun the process of legally defining who was a Jew in Nazi Germany, which would then be used for selecting people who would then be deported and killed subsequently. Right, so denazification is something that the Allies go into Germany in '45 with really vigorous expectations. They're going to be very vigorous about this. The scale of the problem is staggering. It essentially would mean creating an entire new elite. You see this actually in East Germany, where they do pursue a much more vigorous denazification, and they have highly incompetent public administration for a generation and a half, because they fire everybody who knows what they're doing. Right? And so in East Germany, they create this system of training so-called people's judges. And you get a 6-week training course, and then you're a judge, right? These people aren't Nazis. They have that going for them. They're communists, but they're not Nazis. They're usually grossly incompetent, right? You read in the files, there's always, you didn't fill out the forms properly. We can't even tell what the name of the defendant was. Where did you send him to this prison or that prison? We have no record of where this guy ended up. So that is a very serious problem. As a consequence of this, then, these judges who are judging Nazi crimes, particularly starting in the 1950s in German courts, right, at a minimum were of an age of professional maturity in the Third Reich. Now, many of them were not implicated in any particular wrongdoing themselves, so the presiding judge in the Auschwitz trial, a guy named Hans Hofmeier, had served as what's called an Amtsrichter in the Third Reich, so he was like a kind of a municipal judge who dealt with administrative problems, right? Step above traffic court, but not in any kind of criminal cases. As far as anybody knows, he didn't rule on any Aryanization proceedings, he didn't rule on any so-called mixed marriage issues, right? But he was a professional jurist in the Third Reich that can't help but have had some major impact on his thinking about the law, on his thinking about the scope of culpability in the Third Reich, right? There's no question in my mind that the way that the West German Supreme Court develops particularly the jurisprudence of the distinction between perpetrators and accomplices, which really focuses in very strongly on this incredibly subjective side that has the effect of rehabilitating the defense of higher orders as at least grounds for a mild sentence, that is done very much with an eye towards Nazi criminals in mind. I think that is abundantly clear, even though nobody's been able to find a smoking gun to that effect in the archives.
I'm going to try to answer maybe six questions here real quickly. You all heard me now know that quickness is, short answers not my specialty, but I'll do my best. Karl Linus was deported to the Soviet Union in 1987, that's correct. And what did they do with him? Well, they were going to retry him, but he died of natural causes, which even his defense lawyer agrees, shortly after his arrival, so he was not put on trial. Is it illegal to prosecute Nazis in the US? And if so, why can't the law be changed so that instead of just deporting them? As I was saying to a journalist recently, the law is not what we would like it to be always. The law is what it is. If laws were perfect, Congress and basically every other legislature in the world would not be amending laws every year. In order to enact a law that would give us criminal jurisdiction in the Nazi cases, something that Great Britain did actually in the, I believe, late 1980s or early 1990s, if we did that, it would run afoul of the ex post facto clause of the United States Constitution. The British were able to do that because, well, they don't have a constitution, but it can't be done here, alas. There's a related question, asked more or less the same thing, and wanting to know, why these people aren't being incarcerated, and are they still enjoying benefits, that is, before we can remove them. The answer is the Supreme Court has said that our immigration and customs enforcement colleagues may not incarcerate an alien who is to be deported unless he or she poses a substantial threat to public safety. I don't recall the exact words, but that's the substance of it. Or deportation is imminent. Well, it's hard to make an argument that some Nazi criminal in his 80s or 90s or her 80s or 90s poses at this late date a threat to public safety. Since these countries of Europe are so often telling us no, we also can't go to court with a straight face and say that deportation is imminent. I will say, however, that under US law, as soon as we win an order of deportation, removal, the person loses entitlement to federal benefits, Social Security and Medicare. And the very first thing, basically, that we do when we win an order like that is place the call to a colleague of ours at the Social Security Administration in Baltimore, whom we affectionately call the Terminator. He has the job of terminating benefits, and he does. What is the maximum sentence for illegal naturalization in the United States? This comes up in our so-called modern cases, like the ones I showed briefly, Gilberto Verdon of the Dos Eras massacre, anyway, that would be the example. Because we were able to find them before the statute of limitations on illegal procurement of naturalization had run in the United States, those people are subject to a maximum sentence of 10 years imprisonment. In the Jordan case, since this was a first offense, at the time, the federal sentencing guidelines provided a range of as little as probation. So we were very pleased when the judge, recognizing the gravity of the underlying offense, gave him the maximum sentence of 10 years. And finally, do you have any idea how many Nazi criminals are still at large? Are they currently pursuing any Nazi criminals? Well, my office is still actively investigating suspects. We still, again, have individuals against whom we've won orders, whom we're trying to remove from the United States. The German authorities have of late become very active in these cases in the wake of their victory in the Damiano case in 2011, using a precedent or using a legal theory that we had urged upon them. Just to show you how strangely these things work, I'm thinking of another case that David Marwell and I worked on involving an Auschwitz SS man by the name of Hans Lifshitz, whom we found living in Chicago, Illinois in the early 1980s, near the beginning of our program at the Justice Department. And we succeeded in winning his deportation, and he was deported back to Germany, of which he was a citizen, so they couldn't keep him out. He's a citizen, he has a right to re-enter. We deported him in 1983. I have a photograph somewhere of the press conference at which we are announcing this. When we deported him, he became the first Nazi criminal ever deported from the United States back to Europe. Mrs. Braunstein-Orion had been extradited. That's a criminal law kind of a process, a little bit different. So David and I and our colleagues will boast that we deported the first Nazi. Immediately, the German embassy in Washington reacted to the news by telling the press that, well, he can't be prosecuted in Germany. It's too late, too much time has passed. You know, maybe if we'd gotten him 10 years earlier, we could have done something. A few months later, the chief investigator of Nazi criminals in Germany, after visiting our offices and looking at the evidence, announced to the press that, we can't prosecute him because the evidence that the Justice Department has amassed is insufficient as a matter of German law. So that's 1983-84. In the spring of 2013, exactly 30 years later, Hans Lifshitz was arrested in Germany, where he was still living, and charged with complicity in Nazi crimes at Auschwitz by a very dedicated prosecutor, Ralph Dietrich. And alas, his mental health had apparently declined, and this past December, after spending quite a few months in jail, Lifshitz was released by the German court on the basis that he was no longer mentally competent to stand trial. But obviously, if proceedings had been brought, say, sooner than 30 years, things would likely have turned out very differently. And I just found it remarkable that it was too late in 1983 to do anything, and there wasn't enough evidence in 1983 to do anything, but in 2013, oh, now it was time, and there was enough evidence.
Well, this gets very convoluted too in the German case, because at the end of the 60s, they changed the sentencing guidelines for accomplices, and the way the statute of limitations in Germany works is it's based not on the specific offense, but on the possible punishment. So when they changed the sentencing guidelines for accomplices to say it's a maximum of 15 years, before it had been potentially a maximum life sentence, although never actually implemented as such. That meant that accomplices fell under the statute of limitations. This derails what was then a pending major trial for bureaucrats working for the Reichssicherheitshauptamt, the Reich Security Main Office, who was in charge of the implementation of the Holocaust that was pending in Berlin. A lot of people suspect that the change in the law was made specifically to circumvent that trial. That means that from '68 forward, only perpetrators of murder could be prosecuted for Nazi crimes. So a lot of the defendants in the Auschwitz trial would not have been prosecutable. Well, then lo and behold, in 1989, the Berlin Wall falls, and the West German, or the newly united German government, decides that they have a great interest in prosecuting officials of the East German government for crimes committed against East German citizens, in particular shooting people trying to flee to West Germany. And in a series of Supreme Court rulings, they totally revamp all of the jurisprudence pertaining to the distinction between perpetrators and accomplices. You no longer have to prove this internalization of criminal motives, right? And they changed the sentencing guidelines for accomplices back, right? And once they set those precedents, then it becomes possible, and I mean, so Demjanjuk is convicted as an accomplice. That would not have been possible had he been deported to Germany before 1989, because between 68 and 89, that would have been considered under the statute of limitations. So without the transformation in the jurisprudence that gets put in place, mainly with an eye towards convicting communist officials from East Germany, this renewed wave of, well, I don't know if you call it a wave, but renewed inclination to prosecute Nazi crimes that we've seen in the 90s and 2000s in Germany would not have been possible.
Let me again try to quickly go through a bunch of questions. Why was Hess never released from Spandau prison? That's Rudolf Hess, one of the Nuremberg defendants, the last imprisoned man who died in, I don't remember, but not so many years ago. I'm not an authority on that. I know that the Soviets in particular were very opposed to it, and I think they were the decisive voice in that.
Yeah, there's a really great book by a professor named Norman Goda at University of Florida called Tales from Spandau that goes into this at great length. But basically the Soviets, this was like the only Nazi they had left, and they were not going to let him go.
Right. It's noted, same questioner, Professor Barrett, that would be John Barrett at St. John's University Law School, is completing a biography of Robert Jackson. Good point. John Barrett is the authority on Robert Jackson, and a lot of us are looking forward very much to publication of the biography, and even without reading it, I'm going to commend it to your attention. Someone writes, I was privileged to view the Eichmann exhibit last year at Beit HaTfutzot Museum in Israel. Is there a plan that it will ever become an internationally shared exhibit? Great question. I didn't get to see that exhibit. David Marlowe. David says he thinks it will be, and it will come here, I hope? Hope so. Okay, me too. Allies declared in 1943, we'll hunt Nazis to the end of the earth. Explain then how over 1,000 Nazis were able to enter the U.S. knowingly by the Immigration Service, which covered up for them. I don't think it's fair to say that Immigration Service knowingly allowed so many Nazi criminals into the United States. But clearly, people with Nazi pasts, including criminal pasts, were deemed useful by U.S. intelligence, were allowed to come here. The Soviets had their Nazis, the French had theirs, the British had theirs. This was, again, the Cold War rising to the benefit, so to speak, of Nazi criminals. Why was OSI started so many decades later, not till 1979? Well, again, it probably would never have been created but for Ralph Blumenthal's reporting, for Liz Holtzman's advocacy in the Congress. Things don't move the way they should. I share the outrage over that, and I certainly wish that hadn't been so. Quick question, do I happen to know if the portrait of Kurt Waldheim is still hanging in the United Nations and with those of the other UN leaders. And the answer is, yeah, so far as I know, it is. And my former boss and mentor, Neil Scher, a few years ago was visiting the UN on some official business. He's not in the government anymore, and had his photo taken. Oh, David did, you did, okay, of Neil with the portrait. So as far as I know, it's still there. And yes?
I used to work at the UN, and the picture is still there, I'm sure. However, they had to move the picture up, way up. Why? Because we're talking in an area where there's no outsiders coming in.
No public access.
No public access. And they had to move it up because people were coming over and punching holes.
And I think David Marvel's words were, "Prove I did it." That's a great story. And finally, why were there Jewish collaborators? What did they do, and didn't they have Jewish relatives? Well, that would be the subject of a whole week-long presentation. I will say a few things. One, I know we're just about out of time. There is no group on earth that is without its bad actors, and that's true of Jews as with everyone else. There were people like Jacob Tannenbaum, a survivor living in New York, prosecuted by my office for having grievously abused other inmates at the concentration camp at which he was held. People have motives to do all kinds of things, to curry favor with the Nazis in the hope of surviving themselves. There were people who were in almost literally impossible situations. There were others who took advantage of bad situations. Each case, I think, is different.
I'd like to take care of just a little bit of housekeeping before you head out, if you wouldn't mind, please. First of all, earlier, Mr. Rosenbaum mentioned a pad where you can write down your email address if you'd like to receive the newsletter, the online newsletter of the of his office. We'll circulate that pad at dinner. And if you're not staying for dinner, we'll stand outside the elevator now so you can sign it as you head out. You are all cordially invited by Mrs. Heller to dinner on the second floor. And I would like to thank our speakers. Professor Fanya, Mr. Rosenbaum. I'd like to thank our director, David Marlowe, and of course for her guidance and inspiration and outstanding support of Holocaust education, Mrs. Fanya Heller. Join us for dinner on the second floor.